Hey everybody, welcome back to Legal Writing Online. And I'm really excited today because we're going to tackle probably what's called the pinnacle of all legal writing, and that's an appellate brief. And in order to introduce this concept to you, I've enlisted a very great speaker for us to have today, and that is the Honorable Ram Wallace, who is a judge with the 5th District Court of Appeal. Judge Wallace, thanks so much for being here today. We really appreciate it.
Thank you for asking me.
Sure, of course. Let's begin. Do you think you can just maybe introduce yourself to the class?
Sure. I have been a judge since 2008. I graduated from law school in 1992. After that, I served 2.5 years as an assistant state attorney in Seminole County in the 18th Circuit. And I practiced law then from 1995 until 2008 when I was appointed to the 9th Circuit Court bench by Governor Charlie Crist. And then in 2013, Governor Rick Scott appointed me to the 5th District Court of Appeal, which is where I serve right now as a district court judge.
Okay. And for our students who don't know, where is the 5th District Court of Appeal located at?
The courthouse for the 5th District is in Daytona Beach.
And what is the jurisdiction of the 5th District Court of Appeal?
The jurisdiction, there's a lot of nuances as to the jurisdiction, but basically any district court of appeal in the state of Florida, the state's divided up into 5 districts, the 5th District obviously being the last. We have jurisdiction over a number of counties that basically run from St. Augustine, St. Johns County down to Brevard County, then across the middle of the state, including Marion, Orange, Seminole counties back up into St. Augustine. The jurisdiction is primarily, I guess I can conservatively say, 85% of the cases that come out of the trial courts go on appeal to the District Court of Appeal.
And that's a great point for my students to understand. Could you maybe just explain the difference between a trial court and an appellate court? Because I think most of them watch Law and Order, they watch those TV shows, and that's what they see, and they don't really get a good idea of what an appellate court is. So what is an appellate court?
An appellate court is commonly referred to as an error-correcting court. In an appellate court, there are no jury trials. There's no evidence that's presented. There's no jury. It's a panel of judges. In the district courts, it's a panel of 3 judges unless a decision is made en banc, which involves all of the judges sitting together, which is pretty rare in the district courts in the state of Florida. It's not rare to have an en banc decision or an opinion, but for all of the judges to sit in the courtroom at the same time and hear an oral argument is very unusual.
Okay. Well, this is legal writing, and obviously, as I indicated to my students, the pinnacle of legal writing, many people would say, would be an appellate brief, or especially an initial appellate brief. Can you kind of define for my students what a brief is?
A brief is your chance to make argument in the District Court of Appeal or in any appellate court. A brief, you have an initial brief, you have an answer brief, you have a reply brief, and then if you have a cross appeal, you can have whoever is the appellee, which is the responding party, they can also seek affirmative relief from the appellate court. But the brief, especially the initial brief, is your chance. The party who is filing the appellate brief is called the appellant, and the appellant is generally unhappy with whatever the result is or was with the trial court, and specifically they're unhappy with a decision made by the trial judge, and they're seeking a remedy in the appellate court, which is basically an affirmation that the appellant is right and the case needs to go back down for some type of correction.
So it sounds like an initial brief specifically would be the appellant's opportunity to point out a mistake that the trial judge made. Is that fair to say?
That's correct.
And unlike trial court, where you get to put witnesses on, you get to make an opening statement, a closing argument, the brief is really where those arguments are made. It's made in this written form.
That's correct. And that's the challenge. As you're an attorney practicing trial work, your challenge with the appellate brief and the initial brief is to focus the appellate court into specifically what is the issue that you're seeking a review of. It's not the whole case. And as an attorney, you live that case as the case proceeds through the trial courts. The challenge is to focus in the rules of procedure, rules of appellate practice, Rule 9.210, you're limited as far as how long your brief can be, limited to 50 pages. You can ask the court for additional pages, but it really is a challenge, and it's a fine art and a skill to be able to focus the appellate court with those 50 pages.
So I imagine as an appellate judge, you've seen a lot of briefs come across your desk.
Yes.
Okay. What would be some of the positive attributes, techniques that you've seen that really make a brief stand out to you?
I think the main part of that, answering that question would be, number one, your initial brief is your first opportunity to show the court what the issues are, but more importantly, to show the court that you know what you're doing in appealing the case. And the rules lay out what the contents of the initial brief should be and what the contents of the answer brief should be as well. And it's very specific. There's citation, there's indexes, there's summary of arguments, there's the conclusion. It's all specifically laid out as far as how to structure the brief. And those are the best briefs, in my opinion, the ones that state very clearly and succinctly what you're trying to accomplish and want the appellate court to focus on.
Got it. Well, let's look at the flip side then. What are some of the briefs that you've seen that stand out in the negative for you? What are some bad techniques that attorneys have used?
Attorneys that do not follow that structure, and attorneys that automatically seek to expand the number of pages that they're seeking to use for the brief beyond the 50 pages. There are some cases that are so voluminous that they warrant that, but those are there's the exception and not the rule. And just really quality writing, and that comes, there's no substitute for, solid research, clear writing, and then basically revising and editing your brief to make it the most direct, clear, focused document that you can.
Okay. Well, as my students get ready to write their very first brief, what would be some guidance you could give them in regards to maybe the first thing that they should do?
When you start to write a brief, I think you need to write the brief with in the back of your mind, who am I writing the brief for? And you're writing the brief for judges that don't know anything about the facts of your case. They understand that there may be one issue, two issues, maybe three issues that you're seeking a review of and a correction to send back down to the trial court. But really, when you start seeing briefs that have 4, 5, 6, even 10 plus issues, an appellate court, that's a red flag to an appellate court. So I would say you figure out what is the issue you want the appellate court to focus on, and then you really drill down as to how you're going to make it the clearest that you can. I would put my strongest argument first, and if you have unfavorable cases or unfavorable decisions that affect the case, I would be open and upfront with your appellate court about those unfavorable cases as well.
Okay. What about pitfalls? Are there any pitfalls that my students should be on the lookout for to avoid?
No, well, other than what I've already kind of brought up, just thorough writing, correcting grammatical errors. Unfortunately, there are times when when I read a brief. There are times when I wonder if the lawyers ever even proofread what they sent to the court. And when you have judges that are reading briefs and starting to then take inventory and tally the number of grammatical errors and just simple issues that could be resolved just by being thorough and reviewing your work, that distracts the court from what the real issues are and what you want them to be focusing on.
Sure. Well, Judge, just in closing, it's not often that my students will get an opportunity to see a 50 CA judge as college students. Is there any words of wisdom that you can give them as they decide whether they want to become lawyers, if they want to go on a law school, something else? Obviously, you're very successful at being a 50 CA judge. What could you instill in them to give them that drive to move forward to become a lawyer if that's what they want to do?
Well, I would encourage them not to do it because someone else wants them to do it. Like their parents want them to be a lawyer or their parents want them to be a judge. If it's truly what you want to do, I started out when in 1984, 85, I just volunteered to be a runner for a law firm. And I even went in and said, I don't even care if I get paid. I did get paid, which was nice. But I started that, seeing it from that angle, because I wanted to see not only the exciting parts about being an attorney, but also kind of the day-to-day office operation, which is not glamorous and is not fun and that's not what they make movies about. And I was fortunate to have some mentors and some family members that one was an attorney. The other one had been a circuit court judge for 35 years and was kind of instrumental in exposing me to the court system early on as an observer. So I started to follow that path, and I really, everything that I saw I liked, so I decided that I would kind of implement a plan to go do that. But there's no substitute for going in and job shadowing attorneys, going in and seeing what happens in court, trial court, appellate court. I think most people find the appellate court more dynamic and interesting. They find the trial court more dynamic and interesting than the appellate court, which appears to be a much more academic process. So I would encourage them to accompany attorneys like you who are very seasoned in the trial court and see how that operates first before looking into the appellate court.
Very good. Well, Judge, thank you so much for being here. This is really been a treat, an honor. I mean, we can't instill in our students the experience that you can, because you live it every day. You see briefs every day. So thank you so much for being here.
You're welcome. Thanks for having me.
All right, everybody. Well, now's the time. Take a breath. You're going to be able to do this, but it's your turn to write your initial brief. I'm always here to give it help if you need it. Go to it. You can do it.